Okay, we have seen the definition of law. In Hindu jurisprudence, law means dharma, whereas in Islamic jurisprudence, it is known as hukum, that is order, and dharma means a duty, whereas in France, it is known as a droit, means an order or a system which is set up by a government or by an authority. Next, the Roman jurist Ulpian has given his own definition. According to Ulpian, law as the art of science of what is equitable and good. This is the definition of Roman jurist Ulpian. He said that the law is the art, means it is the form, in which form the science of equitable and good has to be adjusted, has to be fit into. म्हणजेच लॉ काय आहे तर लॉ एक प्रकारचं आर्ट आहे किंवा एक फॉर्म आहे. आर्ट म्हणजे काय डिझाईन किंवा त्याला आपण फ्रेमवर्क असं म्हणू शकतो. कशाचं फ्रेमवर्क आहे ते तर इक्विटेबल अँड गुड, जे जे चांगलं आहे जे जे योग्य आहे त्याचं जे काही सायन्स आहे, सायन्स म्हणजे काय त्याचा जो काही टेक्निकल अभ्यास आहे किंवा त्याचा जो सर्वांगीण अभ्यास आहे त्याच्यामध्ये केला जातो त्याला आपण लॉ असं म्हणतो, असं ओल्पियनचं म्हणणं आहे. Now, the definition of Blackstone. According to Blackstone, a law in its most general and comprehensive sense signifies a rule of action and is applied indiscriminately to all kinds of actions, whether animate or inanimate, rational or irrational. Now we analyze this definition further. According to Blackstone, law in its most general and comprehensive sense means he has given a general definition of law. As yesterday I have said that in special circumstances, in exceptional circumstances, there is always exception to the definition, to the rule, or to the process. But in general form, the law is it signifies a rule of action. This is the first thing. The law is a rule of action, means how to behave, how not to behave in a particular situation, in a particular circumstances, or at a particular place. It is a rule of action. जसं कोणत्या ठिकाणी कसं वागावं याची काही पद्धत ठरलेली आहे, त्याला आपण नॉर्म्स असं म्हणतो सामान्य भाषेत. ते जे काही संकेत असतात ठरलेले, ते संकेत आपल्याला पाळावे लागतात. फॉर एक्झाम्पल, आपण कॉलेजमध्ये असू तर कसं वागायचं आहे, आपण घरात असू तर कसं वागायचं आहे, मंदिरात गेलो तर कसं वागायचं आहे, समाजात असू तर कसं वागायचं आहे. दिस इज अ रूल ऑफ ऍक्शन अँड इज अप्लाइड indiscriminately. Now this is the second part. Is applied indiscriminately means the law, that is a rule of action, has to be applied equally to all persons without any discrimination. It shall be applied indiscriminately to all kinds of actions, that is personal action or a public actions. Whether, this is the third part. Now this is a rule of action, whether animate or inanimate, rational or irrational. These actions, whether animate or inanimate, whether it is expected or not expected, the rule of action has to be applied indiscriminately. And next thing, rational or irrational means the action, that is a personal action or a public action of any individual, whether that action is rational or irrational, animate or inanimate, it is not the matter to be discussed by the judiciary, but the law is a rule of action which has to be applied indiscriminately. In short, according to Blackstone, law means a rule of action. This is the only thing. And he further said how it shall be applied. And therefore, according to Blackstone, a law is a rule of action that has to be kept in mind only. Now we'll see the another definition of law given by Hooper. Given by Hooper. According to Hooper, law as any kind of rule. This is another general definition. Any kind of rule whereby actions are framed, that is structured or given in a particular format, and that which reason in such sort defines to be good that it must be done. Sort defines to be good that it must be done. That this is a very interesting definition of a law. This is a very common format, we can say. Now the Hooper defines the law as any kind of rule. He just has said a law means a rule, maybe of any kind. Any kind means maybe it's judicial, legislative, executive, customary, personal, etc. Any kind of rule. This is very important. Law means a rule. Now, what this rule does? This is the first thing. Second thing, by this rule, actions are framed. By this rule, actions are framed. Means what to do and what not to do. When you go to the petrol pump, so is the be done and what not means the actions are governed by a particular rule. Actions are regulated or controlled by a particular rule. The rule may be given by a sovereign authority or maybe be given by an authority who has a control over the area, who has a control over the situation. And that time, that rule becomes the law because that law or that rule has governed the actions. Now, this action which is framed, why these actions are framed? To be good, that it must be done. Means for the benefit of others, what shall be done, what ought to be done, has to be given in a particular format, in a particular rule. And that rule becomes the law according to Hooper. Means this is the object of law. What is? Which reason in such defines to be good that it must be done. Means the thing which ought to be done for the benefit of other. Means this is the object of law. This is the purpose of law according to Hooper. In short, a law is a kind of rule or any kind of rule according to Hooper. Now we'll see the next definition of a law given by Hearing. He is another jurist who belongs to social jurisprudence or sociological school of law. According to Hearing, a law as the of guarantee of the conditions of life, of the conditions of life of society assured by states, apostrophe s, states, power of constraint, power of constraint. Now this is the definition of law given by Hearing. Now here Hearing has given what is meant by law and what is the object of law, who shall issue the law. These three things have been covered here. According to here, law is the form. Now law is the form. Earlier we have seen law is the art of science. Here we have said that it is the form in which order or in which framework the law has to be made. Hearing has said same thing, law as the form of guarantee. Means here the state authority gives the guarantee. Guarantee of what? Guarantee of the conditions of life and of society. Means here we can say the personal life and of society. This is the guarantee of conditions of life and conditions of society. Who has assured it? The assured by state's power of constraint, means by the state. Now here, according to hearing, law is the form of guarantee. This is the first thing. The guarantee is of the good conditions of a life and of society. Now, third point, assured by state's power of constraint. Okay. For example, in Bahubali, you must have seen what is the law? Mera vachan hi hai mera shasan. Now, this is the vachan, this is the guarantee given by the state authority, given by the state. For example, in Article 21, the guarantee has been given by the Constitution itself that no person shall be deprived of his right to life and personal liberty. Means this is the guarantee, this is the assurance given by the state. Assurance of what? The assurance of conditions of life and of society, that your life and the life of society will be secured, will be protected from any constraints, from any violators. Your life and your society shall be protected. This is the assurance given by the state. It means that the law is the form of guarantee. The guarantee may be in the form of legislative law, the constitutional law, executive law, or judicial law. In wherever format the guarantee has been given, that has to be seen. When the guarantee is given by the state, it becomes the law. Means when the guarantee is given, at that time, if your right is violated, then you have all the right to protect and to establish your right in the court of law. Means this is the benefit of a guarantee. Now we'll see the another definition of law given by Solomon. This is the last definition of law. There are many other definitions given by many jurists. For the benefit of jurisprudence, you can refer all other definitions also. Now he'll see the definition of law given by Solomon. According to Solomon, the law is a body of principles recognized and applied by the state for the administration of justice. This is a very brief and very good definition of law given by Solomon. Therefore, in jurisprudence, for studying every topic, you have to refer Solomon, because the Solomon has given a very nutshell or crucial points or ingredients of the particular concept. Now here, according to Solomon, the law is a body of principles. This is the exact definition of law given by Solomon. Principles means everything. You can say it is a equity, you can say it is a rule, you can say they are norms, everything which are principles. Now this is the first thing, this is a body of principles or a set of principles. We can say it is a set of principles. These principles are recognized and applied. This is a condition precedent for the application of law. The law must get recognition, and second thing, the law must be applied. First thing, it should be recognized. Second thing, it should be applied. By whom? By the state. Now this is very important. What is state? In Article 12 of the Constitution of India, you have seen the definition of state. It may be parliament, state assembly, local self-government, or any other authority which has the funding of state or which is regulated and controlled by the state, etc. This is a very important. The existence of state, existence of body, existence of authority is necessary. And what is the purpose of law? For administration of justice. This is the ultimate aim or object of a law. Means every law should be there for the purpose of justice. Justice for whom? For the victims whose right have been violated by the accused, by the culprits. Their rights, the rights of victims, shall be justified, shall be recognized, shall be applied by the state. Means these are the four essential conditions for the law. First, it is the body of principles, of course, given by the state, recognized and applied by the state, and for the purpose of administration of justice. This is the definition of law given by the Salman. While writing the answer, you have to write all these points in your answer. That is what is in by law. Now we'll turn towards the another part of today's lecture, that is a nature of a law. Now, many questions arose what exactly the nature of law is, means whether the law is a natural in format, or whether the law is a positive, whether the law has a sociological traits, or what exactly the nature of law is, whether it is a civil law, whether it is a criminal law, what it provides, what is the nature of a law that has been decided in the area of jurisprudence. Now, in general, it is said that the law is a normative science. Law is a normative science. It is a science of norms which are established in the society. This is a normative science. Now, these two words are of huge importance. Normative means relating to the norms. Now, what is meant by norms? It may be etiquettes, it may be morals, it may be principles, rules, rule of action, anything which provides the norms. Norms means the pattern in which your action is expected to be taken. Means it is the framework, it is the framework within which you have to act. For example, the law has been made for the student by the college or by the university authority. Then it is expected that those students shall behave in a particular framework. They have to act in a particular framework. That is a normative. And we know what is in by science. Science is a research. Science means investigation, or science means a systematic development of knowledge, or a systematic knowledge, or a set of systematic knowledge means a science where the experiment can be done, where experiment can be done according to the changing situation. Science considers the cause and action. Science always consider the cause and action. For example, the heavy rain is there. Now, why heavy rain is there? What is the cause? We know what is the action, heavy rain is there, but why heavy rain is there, that is the cause has to be seen in a particular branch of knowledge, and that branch of knowledge is known as science. मग एखादा लॉ आहे, मात्र तो लॉ तसा का आहे? Why the particular law has been made in a particular format, or why the particular law has been developed by a particular society in a particular fashion, that has to be studied by the jurist, and that is known as a science. And therefore we know law is a normative science, and whole this process is a part and parcel of jurisprudence. And therefore the nature of jurisprudence is investigation, systematic knowledge, or a research in the field of law. Now moving further, we know that the science lays down certain norms and standards for human behavior in a specific situation. What is the science? It is the norms to behave in a particular situation or circumstances, and therefore the law prescribes how to behave in a particular situation or in a particular circumstances. And therefore the nature of law is, it is normative science. Second thing, according to Austin, the nature of law is a command. The nature of law is a command according to Austin, or according to positive jurist. It is a command given by the sovereign authority or by the state. Means if it is appealing in nature, if it is a moral in nature, if it is a positive morality, then it is not a law according to Austin, but it is a command in nature. When command is there, means when you violate the command, the sanction or the punishment is the obvious reason, and therefore the command given by the state is also a law, or it is the nature of law. Then many jurists have agreed, many jurists have agreed that the nature of law is just, equitable, and according to good conscience. According to good conscience, the nature of law is just, equitable, and of good conscience. Means the nature of law cannot be defined in a particular format, or it cannot be fit into the watertight compartment. Whatever just for the human society, whatever is equitable in a particular situation or circumstances, or whatever is a good conscience is known as a law. This is the nature of law according to certain jurists, and this is a very important. Whenever you file a plaint or written statement in the court of law, in your prayer clause you mention this subject, that grant any other order or relief in the interest of equity, good conscience, and just and fair and reasonableness. Another thing which has been added is just, fair, and reasonable. Whatever seems just, whatever seems reasonable is a law in that situation, in that circumstances. Therefore, this is a nature of law. Thereafter, we'll see the Dharma jurisprudence or Bharat jurisprudence in our next lecture.